All right. Good morning, everyone. Our Tenant 101 series. This is our final workshop of the series. We are going to be going over reasonable accommodations as part of this training. I know that we have kind of a diverse group today. We might have a couple property managers, some people from public housing authorities, and case managers who have joined the presentation, which is perfectly fine. But that means that we'll probably get a lot of different questions, which is good as well. I'm Chelsea Heyman. I'm from the Maryland Department of Disabilities. And we have two presenters here today. Diane Dressler, who is a consultant to the Department of Disabilities, and Leslie Dickinson from Disability Rights Maryland. Looking forward to hearing what they have to say about this topic. A little bit of housekeeping for everyone. If you have questions, please put them in the Q&A. It sounds like Diane and Leslie have a plan regarding when the questions will be answered. In between sessions, it sounds like. Is that correct?
Kind of
Yes,
going in and out a little bit.
Yeah, okay, that sounds good. So in between sessions, we'll take a couple of questions, and if you have general comments or technical assistance issues, please put those in the chat. I'll be monitoring the Q&A and the chat throughout the webinar. So without further ado, Leslie, take it away.
Okay, so I guess we need the next slide. Next slide.
Yeah, so why don't I just go ahead and
Yeah,
introduce myself
sure.
and the Maryland Partnership for Affordable Housing, and then Leslie will take it away from there. So again, as Chelsea said, my name is Diane Dressler, and I am a consultant with the Maryland Department of Disabilities on their housing initiatives for people with disabilities. The Department of Disabilities is part of the Maryland Partnership for Affordable Housing, which includes the Maryland Department of Health, the Maryland Department of Disabilities, and the Maryland Department of Housing and Community Development. There are other partners in this, the advisory group for this partnership, which are illustrated on the screen here. And we just want to thank the Maryland Partnership for Affordable Housing for sponsoring this training today. Go ahead, Leslie.
Hi, good morning. I'm Leslie Dickinson. I'm an attorney with Disability Rights Maryland in the Housing and Community Inclusion Unit. Disability Rights Maryland is the PNA. It's the Protection and Advocacy Organization for the state of Maryland. Every state has one. We do a variety of things, all disability related. So as you can see on the screen, we advance the rights of people with disabilities, disability justice, and all the protecting people from abuse and neglect in state hospitals, and residential centers, and residential treatment centers for youth. We're also trying to, as part of the housing unit, trying to work on creating more housing so that people can come out of institutions and actually implement the old Olmstead, Supreme Court decision from years ago. As noted, we also do special education, transportation, voting advocacy, some Medicaid, some Social Security, though that I have to say is limited, and criminal record expungement, as well as trying to resolve some issues with the criminalizing disability, which I don't think is mentioned here, but so next slide. So as far as the housing portion, laws that protect the rights of people with disabilities, people cannot be denied housing because for reasons based on disability. They have to, we're going to talk more about reasonable accommodations, obviously. So I guess this is the roadmap. I don't really know if this is for me, but we can go to the next slide, I think. Next slide. Right, so just like other, so people with disabilities, you probably know this, but it's a protected class, just like other classes of people who have been discriminated against historically. So whether it's race, ethnicity, so the Fair Housing Act, which we'll be talking about, initially it was enacted in 1968, and that was race, ethnicity, religion, probably some other things I'm not thinking of. And then in 1988, it was amended, and so it's referred to, it's still the Fair Housing Act, but sometimes you'll hear it as the Fair Housing Amendments Act. So in 1988, disability was included, as well as family status, and there was one other thing that I can't think of, but so we're focusing on disability. So that's been since 1988. Prior to 1988, the Section 504 of the Rehabilitation Act was enacted in 1973. That was the first law addressing, discrimination against people with disabilities, and that applies when a housing provider, or any other provider really, but is a recipient of federal funds. So for housing, it's any HUD funded organization, or low income tax credit housing, or anything that has federal funds. Section 504 of the Rehabilitation Act will apply. Sometimes there's crossover, the Fair Housing Act will apply as well. But the Fair Housing Act applies regardless of whether there's federal funding, regardless, applies to private housing as well as public housing, there's a few exceptions, which we can talk about later. So I kind of got off topic, I see, but anyway, the reason it's important is that people were segregated and they were discriminated against. And so just like other protected classes, people want to have better lives, better health, and access to affordable, accessible housing in areas of opportunity. So next slide. Right, and as this indicates, disability complaints are the majority of complaints that HUD does receive, violations of the Fair Housing Act. So HUD will, another aspect of, if there is discrimination, people can file a complaint with HUD. But anyway, so HUD also has a lot of guidance, which is really, really good. And I think some of them are going to be your handouts. So I was going to say, I think one of the reasons that the disability complaints may be the highest, and kind of speculating, but it's like people are still, it's surprising that like at this late, 2022, it's not as well known to some people, the rights of people with disabilities and the right to reasonable accommodation, which might account for the higher percentage of FHA complaints related to disability discrimination. Next slide. So yes, so a person with a disability under the FHA and the ADA and Section 504 is any person with a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. So it's important because the person does have to fit the definition in order to be, to be covered by the Fair Housing Act or the ADA or Section 504. But as I say on the slide, it is important that you don't have to be a recipient of Social Security benefits, Social Security disability, anything like that. There are, as we'll talk about a little later, there's people whose disabilities are apparent. If somebody uses a wheelchair or a walker or are blind, or obviously blind, or low sighted. But there are other people with disabilities where it's not as obvious. So if someone's requesting a reasonable accommodation, they might have to provide some documentation, but it's just something that's enough to show objectively that this person does meet the definition for as someone with a disability under the FHA and ADA definitions. As it says, FHA exempts from the definition those whose disability is currently addiction to illegal drugs. Next slide, please. So reasonable accommodation is a change in rules, policies, practices, or services to give a person with a disability an equal opportunity to use and enjoy a dwelling unit or common space. Reasonable accommodations may be necessary at any or all stages of the housing process, including application, tenancy, or to prevent eviction. So as an example, I have a client recently who was a voucher recipient, a housing choice voucher, where once you get the voucher, you're required to go through a voucher briefing. She has learning disabilities and some other disabilities, and she had to go through this briefing virtually because of COVID, and just really didn't understand, missed a lot of what went on. And so it was just a very basic, and also because of that, her voucher timeline was going quickly because you only get initially 60 days to use your voucher. So I just, intervened and asked for a reasonable accommodation for them to kind of give her a different type of briefing, more of a one-on-one type of briefing, and to extend her time to use her voucher. As far as vouchers go, that's a pretty frequent one for a reasonable accommodation, is to extend the time for someone to have the opportunity to find housing and use their voucher. So that, not really an applicant, but sort of at the beginning of the process. There's all kinds of eviction prevention type issues that come up where someone might need a reasonable accommodation, which we can talk more about later if anybody has a specific question. Next slide, please. So, so in addition to the FHA, the federal, that's the federal law, the Federal Fair Housing Act, we have state laws. They're under the state code. We can give you this citation, but the state law pretty much replicates the Fair Housing Act more or less. We have a little bit of additional protections, and I think there's going to be a slide a little bit later that's going to talk about that. So let's see. Okay, here's a good example. There's case law. It's so permitting how a change to how a tenant pays the rent. So for example, so these, and this might sound, some of you may already know this, but some of it is just really basic, and it's surprising that a landlord or property manager would even make this an issue. But there's actually been lawsuits and litigation and case law made on certain things, such as a person who receives their Social Security disability check, in the middle of the month instead of on the first of the month, that they would, request as a reasonable accommodation that they could actually make their rent payment, on the 15th instead of the 1st, which, is not a huge thing. But that's an example of changing a policy, which doesn't at all negatively impact the property manager, landlord, because they're still getting their money. And it's not a substantial change to their business. as I say, no, there has to be a connection between the accommodation that is requested and the person's disability. Here, the example I just gave, it's not the disability per se, it's just the fact that the person has a disability and is receiving Social Security disability, which is why they need to make their payment, in the middle of the month instead of the first of the month. All right, next slide. So when someone needs a modification to their housing, such as grab bars or ramps, or anything else. So let's start with in private housing. So not public housing, not subsidized by any federal program. The tenant or resident can request that the property owner allow the tenant to have a modification done to the property. But the landlord, if it's a private landlord, does not have to pay for it. So the person making the request has to pay for the modification. And there's some examples, and I actually have to look this up, where sometimes they can, the landlord or property manager, they can require the changes to be changed back before the person moves out. But I think that's only where it's internal stuff, and I have to admit I have to look that up. So sorry about that. But there I think it might be later in the presentation where there are actually places where people can apply if they need this done, if it's a private residence and they need the modifications. There are some available monies that in places people can apply. Now, if it's a public housing, now, these days, there's not a whole lot, at least, well, in Baltimore City, I'm not sure where everybody's from. Baltimore City has still a little bit of public housing, but most of it has transitioned into what's called RAD, Rental Assistance Demonstration Project, which are sort of this public-private partnership, but they're still treated as though they're public housing. So that's still public. There's other, I know Prince George's County has public housing. I know Baltimore County does not have public housing. And I'm not sure off the top of my head everywhere that does. But regardless, anything that is public housing or RAD, like pseudo public housing, they would have to pay for the modifications because they are receiving money from HUD. If it's a landlord, if somebody has a Section 8, a housing choice voucher, and they're renting from a landlord, that's still considered a private landlord. That private landlord does not have to pay to make the modifications. However, they have to agree, they have to let the person, the resident, the tenant, have the modifications done. Next slide, please. Okay, I think I just talked about this. It's almost already required. Yeah, HUD has said, this is what I wasn't sure of. HUD has said the tenant may be responsible for restoring the apartment to its original state, but only if it impacts the marketability of the unit. I've never had anyone call and have that as an issue, like, call Disability Rights Maryland to complain that they were moving that this was required. I'm sure it might happen, but that hasn't been something that the people who have called us have not complained about. Next slide, please. Okay, so here's all the citations. Federal Fair Housing Act, and then the Maryland Fair Housing Act, which is, I was saying, in the state government. So it's the Maryland Annotated Code, and it's the state government article. And then there's the Accessibility Code. Section 504 of the Rehabilitation Act is also federal, and that's the one that's been around the longest. And then the Americans with Disabilities Act, and that's a citation for that. The ADA, as covers, as you can see, like there's the state, local government, and then there's a public accommodation. We don't, they say, yeah, leasing offices. Primarily when it's housing, because of the Fair Housing Act, there's less, we tend to use the Fair Housing Act more than the ADA. Though as this points out, if someone is using a wheelchair, they need, and there's a leasing office or the management office has to be accessible to people using wheelchairs for mobility. Next slide, please. So as I was saying earlier, the Fair Housing Amendments Act was, that's when the Fair Housing Act was amended in 1988 to add disability discrimination to the Fair Housing Act. Sorry about that. All right, the Fair Housing Act applies to obviously all public housing, and it applies to all private housing except for, so if there are 4 or fewer units and the landlord and the owner lives in one of the units, then it is exempt. If a landlord or owner owns only 1 or fewer than 4, one individual, I think it's actually fewer than 3. So let's say there's a landlord or a person who owns 3 single family homes or 3 individual condo units. If it's fewer than 4, they're exempt, except, and I actually have a case on the Eastern Shore right now where if the landlord or owner is using a real estate agent. So what the Fair Housing, in addition to Fair Housing Act prohibits discrimination in sale or rental. We tend to talk about the rental and keep, people who need reasonable accommodations to stay in their housing, but it's sale or rental. So there's all different time periods when it might come into play. So if a landlord or owner is using a realtor, even just to sell their own house, they can't discriminate against someone with a disability who might be trying to buy the house, or if they're renting, who might be trying to rent the house. Even though if they were doing it on their own and they had no real estate company, then the Fair Housing Act would not apply. I have a situation where the landlord's trying to sell the property where my client lives in Ocean City. And anyway, I can't give too much detail, but anyway, for some reason, they want to come in, and there's all this, still COVID protocols and et cetera, but she's asking for reasonable accommodation and they're not complying. And so it's only because the owner is using a real estate company to try to sell his property and to be contacting the current residents that the Fair Housing Act comes into play. If he was just doing it on his own, then the Fair Housing Act nor the state Fair Housing Act would not apply. So let's see. So let me get back to the slide here. So it does apply, other than these, very unusual small exceptions. Prohibits discrimination, sale, rental, terms or conditions on the basis of disability. It's also if you're a person, like with someone with a disability in your family. So let's say it's a couple and their child has a disability. So the ones buying or renting don't have the disability, but they're associated with a person who has a disability. So the landlord or owner or whatever cannot discriminate against their child, even if they're the ones paying for, or trying to rent the place. The application, similar, and non-discrimination in application screening. Somebody might need reasonable accommodation for help with the application, or waiving some type of requirement that the application calls for. I don't know if we're going to talk about this, but there's some of this is the criminal record background check stuff. There's HUD is really interested in making sure that criminal background does not discriminate. Criminal background screening can discriminate against both African Americans and Latino people of Hispanic descent, and also people with disabilities. So that's something to be aware of. There's a new, not new guidance, but they had just reissued their old guidance from 2016, sort of re-emphasizing that this is a really a serious concern of theirs. And I'm not sure if it's one of the handouts, but if it's not, I can make sure that you, anyone who's interested can get a copy of that. So this affirmative actions to provide opportunity at a minimum, I'm not sure if that's referring to the Fair Housing Act has a requirement for housing that was built after 1991, and it requires to be sort of more easily modified. So to have the studs already in place for grab bars to be put into bathrooms, and different. It doesn't require all this stuff to be done, but it requires that it be constructed so that it can be made accessible more easily. So that could be what that's referring to, but to be honest, I'm not sure. But next slide. All right, so let's see, we talked about the exemptions. We have the for sale by owner. Oh yes, housing operated by organizations and private clubs with limit occupancy because they're private, which I don't know, it's still kind of weird to me, but and the owner occupied buildings with 4 or fewer units. Now the housing number 3, housing restricted to seniors. I think initially it sounds like, oh well, you can discriminate against people if they're in senior housing, but what it really is that they're allowed to keep other people out. They're allowed to discriminate technically if you're under 55, because it's housing that has gotten permission to be over 55 or over 62 housing. All right, next slide, please. So under the Fair Housing Act, it is illegal to refuse to sell or rent, to make housing unavailable, to advertise housing as available only to people without disabilities or to those who can live independently. So these code words that might be used, to discriminate in terms, conditions, privileges in sale or rental, like requiring a co-signer or a case manager, a refusal to make reasonable accommodations, which must be requested. We can talk about that later. I mean, it's always good, reasonable accommodations, even though if it's really good to use the specific language, but if someone just happens to make a request on their own and they're just saying, this is what I need for this reason, these magic words are not required. The landlord or the property manager are expected, if it's reasonable that they should understand what the person is asking for, then that would be considered a reasonable accommodation. It doesn't have to be in writing, always better. Everything's always better if you put it in writing, but it's not required to be in writing. Refuse to permit reasonable accommodations. It's also discrimination. threaten, coerce, retaliate against anyone for exercising a fair housing right. There have actually been cases where, even though, I read about one recently, even though where the Fair Housing Act like actually may not have applied, but the retaliation in and of itself was a violation. Retaliation is a really like a really serious issue. You even under Maryland law, unrelated to the Fair Housing Act or the State Fair Housing Act, there's when landlords, when someone asks for something, whether it's but let's stick with disability. It's even if it's not, even if we're talking about the state law, if someone requests a reasonable accommodation and the landlord decides, oh, they're just too much work, this tenant or whatever, and then they try to, in fact, my case I was talking about earlier, that was another thing that they did, was they actually retaliated. So that is, it's a separate like violation of either Fair Housing Act or Maryland law, depending on the specific circumstances. I wanted to say, oh, the make housing unavailable. I wanted to explain that a little bit. It's sort of like pretending, it's like you're trying to rent or sell or whatever, but then you're not, when certain people show up or inquire, then, some might say, oh, it's already rented, or it's already, it's not available anymore. So it's that type of thing. It's sort of that deception. I mean, you obviously, I think people now know, landlords, property managers, whatever, that they can't advertise housing, and they can't blatantly say, only these people can apply. But they might do other things that are more subtle, that are actually also discriminatory. Next slide, please. So we've talked about this a little bit. So the reasonable modifications. Yeah, that the weather restored, definitely if you're widening doorways, that is not something that can be, anyone can require to be restored, because it doesn't, to have a wider doorway does not infringe on a future resident. I can't actually see what's behind this, but it's probably what we already talked about. Installing grab bars, installing access to a route to a sidewalk. Tenants are permitted to make modifications to common areas, again, that they have to pay for. Yeah, and the landlord can require approval of plans of the contractor, but cannot require more expensive modifications. I had a case last year where my client who was actually a condo owner, and he was trying to get the entryway to the lobby to have an automatic door, and because he was a quadriplegic, so he can do, he could push his button, and it was like they put him through quite a lot in terms of, this plans and contractors and who was going to be approved. I mean, it was a huge thing, because they're talking about it interfering with their security system. So that's probably a more, that's a little bit more complicated than, having a ramp put in or grab bars. But so it can be, if it's something that's a little bit more, if it's more complicated or has to kind of be, intertwined with some system, then it's got to be more difficult. But they, as long as it can be done, then it should be done, as long as the person can find the funding to have it done. Once it is done, the landlord has to maintain the modification. So the tenant might have to pay to have it done initially, but the landlord has to maintain it, the property manager, whoever. Next slide, please. Okay, there you go. And no mention of automatic doors. All right. A ramp to allow access to a dwelling through an exterior door, grab bars in the bathroom, levered handles so that people don't have to do that knob thing. Yeah, alarms for vision or hearing impaired. So, you know, obviously if it's someone who is vision impaired, then it would be an oral, verbal thing. Just like they now have at some of these crosswalks, they have, you know, for people who are vision impaired, they have the alarm type things, and lowered mailboxes and light switches. So those are examples. Lowered counters would be another thing. Sometimes it's just basic. Well, I guess that's not really modification, but you know, there's can be things having to do other things in the bathroom, like a roll-in shower, things like that. So there's all kinds of possible things that people might need. Next slide, please. So these are some of the programs. So this could be a pretty good resource for people who need modifications. So I assume that you all will be getting a copy of this slide so that you will have this these resources. Next slide, please. Okay, so the types that are not considered modifications but are reasonable accommodations. So landlords, you know, property managers, they're not allowed to charge for a reasonable accommodation. If so, an accommodation is considered reasonable if it, I mean, it has to be necessary and connected to the disability, but it's reasonable unless this bottom thing, your housing provider must grant a less undue financial and administrative burden. So that's different than, you know, that it might cost them a little bit of, like, they can't charge a fee for the accommodation. They can deny the accommodation if it really is a financial and administrative burden. Now in Maryland, that burden is on the landlord. So if a tenant resident requests a reasonable accommodation, and if they make what's called like a prima facie case, they give enough information to say, okay, this is what I need, this is why I need it. You know, they're a person with a disability under the FHA, and this is the connection. Like, I need this ramp because, oh wait, I don't want to say ramp because that's modification. I need this, you know, this waiver of this policy for this reason, you know, and it's based on my disability. Well, the landlord, they have to, if they don't want to do it, it's their burden to prove that it's not feasible because it's an undue financial and administrative burden, or that it's a change to the way the whole program. So yeah, and so if it's, you know, some nominal cost, like if somebody wants to move to the ground floor, the first floor from the third floor because their child's in a wheelchair and there's no elevator, then, you know, they should be able to move without being charged, you know, some transfer fee or something like that, because it's really not a financial burden on the landlord, because they just want to change apartments to accommodate the person with a disability. So there's no reason for any type of fee, and that would be illegal. It would be a violation of the Fair Housing Act. Parking spaces, as I say, you know, make just doing the restripping, they call it, but, you know, making it obvious that it's a handicap parking space, disability parking space. The person with a disability must make the request, or someone must make the request for them. As I said earlier, it's obviously the more clear the request is, the better, but if it's just something that the landlord should understand is a request. Someone says, I need this because of my disability or because of this situation, then they should understand that that's what the person is, asking for. It must be a qualified person with a disability under the Fair Housing Act or the Rehab Act. And that the requested accommodation is because of the disability, and the accommodation is necessary to afford an equal opportunity to use and enjoy their housing. That's kind of the FHA language. And then the housing provider must grant unless an undue burden. Often you'll have the person request the accommodation, and then, the landlord, there might be what they call an interactive process, like maybe the landlord doesn't want to do exactly what the person's requesting. And so they might say, well, that's going to be too difficult, but we'll do this. So that there can be an interactive process, but ultimately the person with the disability is considered to know more about what they need. But it's all of these reasonable accommodation requests are supposed to be viewed and analyzed sort of independently. Like, it's not like, oh, there's this, everyone's the same. It's like and that's partly why there's an interactive process. It's like, okay, this is this person and this is their situation and this is the landlord, and and there's, they can either just say yes, which is obviously the easiest and best thing that can happen, but sometimes they just, go back and forth. Now, landlords cannot just ignore the request. That's considered a denial. The reasonable period of time is usually considered to be about 30 days. So the landlord is required to respond in some way to the request. They can't just ignore the request. Next slide, please. Okay, so we talked a little bit about this. So if the housing provider is claiming that the requested accommodation would fundamentally alter their program, or if it's an undue financial burden, then and what this is saying is if the defense is met. So if the housing provider is able to show that it really would be an undue financial burden and or fundamentally alters their program, then that's not the end. They would still have to consider alternative accommodations that would not be an undue financial burden or a fundamental alteration. So here's an example. Okay, with the dumpster. Tenant uses wheelchair, can't get to the dumpster. The tenant requests maintenance to collect trash daily. So that might be an undue burden. So they say doing it twice a week. That's a kind of an easy example, but yeah. So I guess if you're in a smaller program, there might be less, things you can't do, or that you express that you can't do. But it doesn't mean that the landlord can just say, no, I can't do that, and then they do nothing. So there has to be some other ongoing discussion and possible alternative accommodations. Next slide, please. Okay, so these are all the types of buildings which are covered. Multifamily with 4 or more units. The landlord has to live, if it's 4 units, the landlord has to live there. I mean, to be exempt. So if a landlord owns a building with 4 units and the landlord doesn't live there, then that building is not exempt. That building is included. Buildings that have, so buildings with an elevator, all of the units are covered. I should back up, because what this is referring to is this March 13th, 1999. What I mentioned earlier is that they developments or buildings that were built for first occupancy after March 13th, 1991 have to be more easily modified, have to already have the wider doors, have to have the studs for the grab bars to be added. So they have to be able to be made accessible more easily. So, but in a multifamily building without an elevator, only the ground floor units have to be built in that manner. But if there's an elevator, then all of the units in the building have to be built in that way. And they have to have more, at least four more units, depending on if the landlord lives there. Oh, there's something I was going to say, but all right, maybe they'll come to me. All right, next slide, please. Okay, so here's examples. The reinforced walls that I was talking about. This is a very frequent request for accommodation. Probably one of the easiest, least expensive ones to accomplish is to put the grab bars in. So, but if the reinforced wall is already there, which they're required to be after 1991, then certainly it's easier to just add the grab bars because the studs are already there for them to be put in place. Lower controls, electric light switches, air conditioning switches, the kitchen size, so that a wheelchair user can maneuver in the kitchen, and an accessible route to various common areas, lobby bathrooms, accessible entrance so they can get in and out of their unit, and management office and laundry room. So all of that is required, and they have the link here for the HUD website. The HUD has an entire, well, that's it, the design manual. It's very, very detailed, and it's like it's really for people who are actually designing and building, because it's very very complicated. So anyway, next slide, please. Okay, so this is the Maryland Fair Housing Act, which we mentioned earlier. So as I was saying, it's equivalent to the Fair Housing Act for certain protected classes, but in Maryland we've added as protected classes, meaning if someone is in a protected class, they cannot be discriminated against. So we have added sexual orientation, marital status, gender identity, and source of income. Now, source of income was added in, well, it was October, I'm thinking it was 2020. Could have, yeah, 2020. So source of income discrimination is, is if someone is using a housing choice voucher to try to rent. So any landlord in this state can no longer deny to rent to someone with a voucher, or other types, or it could be that their income, Social Security, or some other income, or in our theory, like the DRM and other legal services attorneys, we've also been looking at this for the emergency rental assistance under COVID, because some landlords have not wanted to take that. So that would also be a source of income. This is very new. There's no case law on it, interpreting it. We're working with the Maryland Commission on Civil Rights, which is, our state commission where people can file complaints. And we're kind of trying to work with them and educate them on the actual implementation of this and what it means, because the primary way, at least the primary way that's been brought to all of our attentions in terms of vouchers, is landlords, property managers trying to require that the voucher holder has income that is 3 times the market rate of the actual apartment or house that they're trying to rent. So that would be, so if the rent is $2,000 a month, let's just say for a house, that would, they'd be saying, well, the voucher holder has to show that their income is $6,000 a month, not whatever the portion, the voucher holder is only going to pay, their rental portion is only going to be 30% of their income. So let's say 246, let's say they make $600 a month, their rental portion is going to be $200 a month. So they should, so the landlord should be able to ask that they can prove that their income is $600 a month. But what they're doing is they're wanting the proof that it's $6,000 a month, in which case that person would not even qualify for the voucher program because their income would be too high. So that's one workaround that landlords who don't want to take vouchers have been doing. I'm sure there's other ones, and of course there's the credit checks and this background check and all the things that limit the ability of like our clients to access certain housing. But so the source of income is just, at least it's an additional attempt by this state, by Maryland legislature to get more people to accept vouchers and other sources of income. Let's see, multifamily housing of 4 more units, that's the same. Some jurisdictions have local ordinances with additional protections. So for example, I know I'm focusing on the source of income, but prior to Maryland passing that legislation, I believe Montgomery County had that law, maybe Howard County, and I'm not sure, but and there's other local laws that can be more protective or provide more protection. So when people want to file a complaint, someone might file a complaint with HUD, and more often than not, HUD is going to refer it to the Maryland Commission on Civil Rights anyway. But you might get lucky and HUD might keep it. So it's worth maybe having, if you have a client or a tenant or whatever, it might be worth it to file with HUD just to see if they keep it. And this says complaints can be made up to 1 year. Oh, Maryland Commission on Civil Rights, 1 year. So I guess maybe it is 1 year when it's an administrative. You can file in court within 2 years from the date of the discrimination, or if it's ongoing, then it's ongoing. But so I assume that that's correct because Lucian probably put it in there. And then local human rights commissions, Baltimore City has one. In fact, they might all have them, but I know Baltimore City and Baltimore County have them. I assume, yeah, Montgomery County and Howard County. So so you can check to see if you're depending on what county you're in, to see if they have it. Sometimes the local, like Baltimore City Human Rights Commission has a much better understanding of the source of income law than the state MCCR does. So if you're in Baltimore City, you're probably better off filing with the local, or with HUD or with the local rather than MCCR. So anyway, next slide, please. So similar requirements, except that to be covered under Section 504, the a housing provider must receive federal financial assistance. So pretty much it's a pretty similar, everything else is similar. In fact, because the Rehab Act has been around since 1973, a lot of the, at least in the court decisions and case law, the request for reasonable accommodation for the Fair Housing Act and the ADA, a lot of it uses this, they've used this analysis that was previously done under Section 504 because, it's already been done and it's all very similar. So they consider the courts and Congress when they passed, the Fair Housing Amendments Act that actually referred back to Section 504, and that it would be a similar analysis in terms of the reasonable accommodation requests and, that whole everything we've been talking about and how. So requirements include accessibility. So, but the difference in terms of accessibility, again, is like these programs have to pay for the modifications and, all of it is the same except that it's almost like more stringent and more obvious. And in most, and the places that are covered by Section 504 that receive federal funds, they're pretty, aware. No, they're not all aware, but for example, they all know that they have to accept vouchers. I mean, if it's public housing, they don't, because they're public housing, but like a low income housing tax credit building, which has getting federal tax credits. They know that they're required to accept vouchers even before the source of income law was passed, in the state. They have to have these various, the communication methods and the accessibility with the new construction. I'm sorry about that. Or paying for the modifications. All right, next slide, please. Okay, so this is just saying who's covered under Section 504. Public housing, including RAD, the rental assistance demonstration project, where they come up with these names. So RADs are what used to be public housing in Baltimore City, and actually I think in Prince George's County they're trying to do RAD. So basically it's not here because maybe it was, maybe this was made before the RADs became more popular. Project-based Section 8, project-based rental assistance, which is also related to Section 8. Oh, home funds. So, home funds are also federal funds. USDA, and so rural housing, that's, gets federal funds, and Section 202 supportive housing for the elderly. So all of that would be covered by 504. They just have higher, it's not higher requirements, but that they have to pay for them, et cetera. As they say here, not tenant-based Section 8, so the landlord wouldn't have to pay for the modifications. So they're saying older low-income housing tax credits are not required. Okay, prior to 2018, they're not covered. So that was my mistake. So, okay, so low-income housing tax credit funded from 2018 going forward. Okay, next slide, please. All right, yes, with new construction, if it's federally funded, 5% of the units have to be accessible. It's UFAS, so that's Uniform Federal Accessibility Standards. So 5% at least have to be accessible, and there have to be accessible pathways from the project. So you come out, you need to be able to, there's a problem in Prince George's County where they actually built, they built the UFAS units, but they did not properly create the accessible pathways. And then 2% of the units are required to have hearing or vision modifications. Units must be dispersed throughout the project, so they're not all congregated and or segregated in one area. They have to make the other modifications if needed, such as changing the door handles, lowering the light switches, switching a refrigerator to bottom freezer side by side, and installing grab bars at no charge to the tenant. Everything else has to be accessible. Lobby, mailbox, laundry room, daycare facilities, halls, elevators, entrances, and management offices. So even if the development predates implementation of Section 504, they may have to make modifications to common areas to allow equal use. So I'm not sure why it says 1988 there, because that was the year of the Fair Housing Act. But so yeah, I'm not completely sure why that's there. It might, maybe it should be 1973, but we'll get back to you on that. But for the most part, I would think that any housing that's covered by 504 would have to make modifications to the common areas. But if that is something that is an issue for any of you, you can double check with me and I'll make sure to find out what's going on with that date there. Next slide, please. All right. Examples of undue financial burden and undue financial and administrative burden. Okay, so I guess what they're saying is even if it's Section 504 building, requests for modifications that cost too much, walk-in showers and high-rise developments that have concrete floors. Okay, so I guess, yeah, they're saying that even a federally funded housing provider could refuse to do something that's too expensive. An existing subsidized housing and request for modifications to create a new UFAS unit if the development already has 5% of its units which are UFAS compliant. Yeah, and yeah, I think that if someone's in a unit that is not UFAS compliant and there's already 5% and but they need more accessibility, then they would probably there are units where some people don't need a unit that is like completely UFAS compliant, but they need accessibility features. So I think that would be a situation where if there's already the required 5% of UFAS units, the person would be requesting whatever is specific to their needs, and or would request to get on a list to transfer if a UFAS unit became available or something like that. Requests for programmatic changes that are outside of the main business of housing. Requests to walk or care for service animals, right? So if something, yeah, that's an example of something that's a fundamental alteration or just not within the purview of the program, such as, yeah, no one who works for in the housing management has to walk someone's service animal, or yeah. HUD will consider a request to use residential receipts to pay for alterations under Section 504. If the property is owned by a housing provider that is not covered by Section 504, then the Fair Housing Act, and under the Fair Housing Act, the tenant would still have the right to make the alterations at their own expense, which is what we've been talking about before. Next slide, please. Okay, so this is the interactive process that I briefly mentioned. So the housing provider, if somebody makes a request for a reasonable accommodation, the housing provider has to respond. And if they can't just say yes, then they should be engaging in this interactive process to try to figure out what accommodation can be made. If there are several options, the individual with the disabilities preference should be accommodated, unless it's an undue financial and administrative burden. Housing provider may suggest alternate accommodations. Public housing authorities and recipients of federal funding have a duty to affirmative market and outreach analysis of policies and practices to foster inclusion and eliminate discrimination. So affirmatively, there's like affirmatively further fair housing, and I'm trying to think of, there's affirmative marketing. So I guess when they're making sure that you're marketing to, places where a whole variety of people, including people with disabilities, would be aware that, let's say, a new low-income housing development is opening up. So they should be affirmatively marketing to a variety of places where anyone in a protected class, not just people with disabilities, but so that they are aware that there's this new development opening up. Applies to FHA covered properties too. Yes, I think we're talking about the affirmative marketing there, which also applies to FHA covered properties. That's what. So there's affirmatively furthering fair housing, which is also what they're talking about. Affirmative marketing really is part of that. Is something that was reinstated, as they say, interim rule reinstated in July 2021, because it was removed as, it's actually in the statute, but it was removed as a rule under the previous administration, and then it was brought back. So it's like anyone receiving HUD funding, any entity receiving HUD funding is required to affirmatively further fair housing and affirmatively market to, sometimes it's called least likely to rent. We have a voluntary compliance agreement with sort of a HUD lawsuit thing with one of the counties, and so there's certain people that are least likely to rent or least likely to be able to use their vouchers. And so the idea is to try to get the people who are least likely to rent to actually have access to this housing. Next slide, please. So Title II of the Americans with Disabilities Act covers activities of state and local government, regardless of whether they receive federal funds. So it might just be a local government or state, and what if their buildings or something that doesn't have any federal money. Requires that these entities ensure access to affirmative service, including PHAs and housing offices. Requires people with disabilities to have equal opportunity to participate and receive equal benefits of government goods, services. I can't read that last thing. State and local governments are required to follow architectural guidelines for new construction and alteration of buildings and facilities. Must provide reasonable accommodations and effective communication. And Title II requires housing owned by or operated by the state, county, or local government to make reasonable accommodations, reasonable modifications to both new and existing facilities. So again, it's like, oh, because they have, it doesn't have to be federal money, but their state or county or local, that they have to make the reasonable accommodations to their facilities. Sorry. Next slide, please. Right, so the ADA doesn't cover private housing, nor expressly housing, but covers public entities such as PHA. So it doesn't cover private housing because, you know, the FHA already covers the private housing. So other than the, you know, entryways or, you know, public. So the ADA is more like public areas, public space. The FHA is for like specifically for housing. But it does cover areas again that are the public spaces in a housing development. So leasing offices, swimming pool, covers services to obtain housing, such as administrative offices, application process inspections with certifications. So somebody who's trying to go through an application process can request a reasonable accommodation. I mean, if they're applying for housing, they could technically apply for that as though it's under the FHA, but it could also be under the ADA. Accommodations are not required if fundamental alterations or undue financial or administrative burden. Next slide, please. So Maryland Accessibility Code establishes minimum standards for accessibility in housing, requires multifamily developments, which are 4 units or above, that undergo rehabilitation or rehab, be brought into compliance with accessibility standards. Is enforced by local jurisdictions through their code enforcement, and tenants or applicants may enforce under certain circumstances. Sometimes that last one, it's because sometimes like statutes are written for, you know, some public entity to be the enforcer. So, you know, it's just pointing out that the tenant or the applicant also has the right to enforce under certain circumstances. This is actually interesting though, because, and I meant to say this earlier, that the Fair Housing Act and in the design standards, where after March 13th, 1991, they're required to have these certain building standards that could create, you know, more, you know, accessibility more easily. They don't. It only matters if the house was built for first occupancy before or after March 1991, not if it undergoes rehabilitation. So the state standard is actually more stringent because it's also requiring that if they undergo rehab, that they be brought into compliance with accessibility standards. So that's actually a higher standard that Maryland has than the FHA with the design and accessibility standards. Next slide, please. Okay, well, we have an explanation of the various types of housing. Public housing, including RAD, rental, I always forget what that stands for. Rental and demonstration project, rental assistance demonstration project, I think is what it's called. I don't know where they got that name. Anyway, so public housing and RAD, RAD, low income housing tax credit in Maryland, units funded starting in 2018. HUD 811 units, section 811, project-based rental assistance. Oh, they do have RAD here for the first time. Sorry, I missed that. USDA and RDA, which is rural housing, subsidized housing. Section 202, supportive housing for the elderly, and continuum of care funded housing are the federally funded housing units. State locally funded, MFP bridge subsidy, Weinberg apartments, community choice homes, local county programs and DDA rent subsidy programs. And private market units must accept tenant-based rental subsidies, housing choice vouchers, fair share, HOPWA, NED category 1 and 2, FUP, BASH, and mainstream. Next slide, please. So compared to state, contrasting market rate and state. So market rate housing. Private owners have no requirement to keep rents affordable. They can set rent wherever they think what the market will bear, and raise rent at least renewal in most places. No requirement to renew a lease. Now, I'm just going to stop here for a second. This is true, like that, the private owners can raise the rent. You know, let's say you have a year lease and it's going to expire, and they raise the rent. So you expect a nominal increase every year, but they can increase it more, and of course with the market the way it is, but there is in part of the retaliation that I mentioned back there under the state law, if it appears that it's for retaliatory reason, like if it's a really excessive rent increase that appears to be retaliatory, then there's possibly a way to address that. So yes, they can, but if it's just depending on the facts and the circumstances, it's possible that they're doing it for the wrong reason. No requirement to renew a lease, similar, except just like, so let's, just like we're talking about before, you can't keep a person with a disability or anyone from any other protected class from renting someplace to begin with. So if the reason to not renew is actually for discriminatory reason, then you may have a violation of the Fair Housing Act. I had a case last year where my client was, my client I guess was the little boy, but he lived with his grandmother. He had autism, and a neighbor was complaining, had been complaining, the neighbor actually had moved, but she was complaining that the little boy was too loud, and which was completely related to his disability. There was some dispute over it anyway, but regardless. And so they were telling my client, the grandmother, that they weren't going to renew the lease. Well, it was very clear the reason. They tried to pull back on the reason, but it was very clear that was the reason. And so that was an example where I wrote a request for reasonable accommodation. And even though I, in that request, did indicate that there was a dispute over, this neighbor's claim that this child was actually making excessive noise, and he had lots of support, and we had his, support. We had other, letters and things. But anyway, they did let them renew the lease for a year. But the point being is that if they're not renewing for discriminatory reason, then and this was a private apartment complex. It wasn't subsidized by anything. She didn't have a voucher. It was just, regular place. But they still they can't discriminate, whether it's in the initial renting or the non-renewal. So just something to keep in mind. Owner may set reasonable requirements for minimum income. Okay, and we talked about that with the voucher. So yes, the owner, to ensure that they're going to get paid. So let's just say it's a private complex. 3 times the rent seems to be like the going thing. I don't know. I can't tell you in a private situation what's reasonable or what's acceptable. I mean, we all know the rents are getting too high for like most everyone. So I don't really have a whole lot to say about what requirements for minimum income they can in a private setting. As we discussed, the tenant, you know, the landlord has to allow the reasonable modifications as long as the tenant pays for them. The owner must make reasonable accommodations unless undue financial administrative burden. That includes private, market rate places. If renovating, the owner must comply with the accessibility requirements of the Maryland Accessibility Standards, Maryland Accessibility Code. Maryland law prohibits discrimination against tenants based on their source of income, as we discussed. And eventually, in the next couple of years, hopefully we'll have some case law on that, interpreting what that really means, because we know that property managers and landlords are not all compliant with the requirement. And that also does not apply to buildings with 5 or fewer units if it's owner occupied or to rented rooms in a dwelling. I think most of these actually don't apply to rented rooms in a dwelling. Next slide, please. Okay. Okay, so if it's state funded, even if it's a private owner, but if it's state funded, so nonprofit or a partner, funded pursuant to competitive application. I mean, we know low income housing tax credits are approved that way, that's actually federal funding, but other like DHCD programs that are competitive must renew the lease each year except for good cause. So this is just similar. It's similar to the HUD standards where you can, the lease automatically renews, and the landlord cannot refuse to renew unless there's good cause, which is basically almost like a breach of lease standard. So in order to evict someone during the lease term, you have to prove breach of lease. And so good cause to not renew, it's similar. It's like, well, there has to be a specific reason, and the landlord would have to, if challenged, the landlord would have to be able to prove what the reason is, what the good cause is for not renewing the lease. Okay, so rent set on affordability requirements. Usually that's 30%. I know, like under all the HUD programs, it's 30% of the person's income. I'm actually not as acquainted with all the state programs, but assume it's also 30%, since that's what's considered affordable for everyone to pay in housing costs. Some tenant services must be provided. Excuse me. Maximum income requirements set at 0 to 60% of area median income. Owner may set reasonable requirements for minimum income based on tenant paid rent if running with a voucher. Okay, so this is exactly what I was talking about. So here it's clear because we're saying, oh, here it's state funded. So the owner obviously can only set, reasonable requirements for the minimum income based on the tenant's portion of the rent, as opposed to what some of the private owners are doing to avoid accepting vouchers. Because I know I keep harping on that, sorry. If owner receives low-income housing tax credits, they may not refuse to accept housing vouchers. So actually, as I'm stating, no one in the state can refuse to accept vouchers, but they can still do the background checks. Owner must take steps to ensure that wheelchair accessible units go to persons who need them. But this is very important, because we have found, not recently, but we have found in some situations that housing authorities have actually, they they just give the accessible unit to the next person at the top of the waiting list instead of to the person on the list who, on the list for an accessible unit. So that's an important thing to be aware of. Many owners agree to extended affordability periods. I'm actually not completely sure what that means, except that some, housing might be made affordable, for 15 years. So it could be that they're agreeing to extend it for beyond the period that's required. Often the opposite occurs where it's like, okay, we're done here. Now we can make this market rate and people lose housing. But many owners agree to set units aside for people with disabilities. Developments funded in 2018 or later, owners must pay for modifications. Next slide, please. Okay, how to know if the development is receiving or has received federal funds. Well, luckily we have the National Housing Preservation Database. And I guess it's funny, it's saying reasonable rents. I guess if they're receiving, I don't know. I mean, pretty much tenants required to recertify. Is the development federally subsidized? Okay, well, if it is, then tenants are required to recertify yearly. If it's HUD subsidized or federally subsidized, there has to be a lease addendum, the HUD addendum. The rent is based on income. And you can ask or you can call HUD. I think it should be in the database, but it's a good question. Like, people usually know if it's public housing or if it's RAD housing, but you may not know if it's low-income housing tax credit property, or if it's just a HUD property that's not run through a housing authority. So it's not public housing, but it's HUD subsidized housing. So that should probably be in the preservation data base. And there's actually, and it's not on here, but I could get it to Diane. There's also low-income housing. You all might have it because, again, I don't really know who I'm talking to. But there's a low-income housing tax credit database that shows every tax credit property. So yeah, if anybody needs more information on how to find out if it is federally subsidized, you can let us know. Get that information. Next slide, please. Oh, next slide, please.
Okay, Leslie, this is where I take over.
Great.
So thanks so much for your presentation. We're running a bit behind.
I know, sorry.
It's okay. We're not going to take questions till the end. I will go through my section because much of it's covered also under the law section. So I will go through it as quickly as possible to make sure we have a few minutes for questions. So reasonable accommodations can be requested by a person with a disability or someone on their behalf at any point during the pre-leasing, during the tenancy, and during lease termination, or even through eviction. So there is no point at which a reasonable accommodation must be requested by. It can be requested at any time. This slide lists a number of common barriers to accessing housing for people with disabilities, such as getting or staying on a waiting list, not having documentation that's required, and this includes state-issued photo IDs, birth certificates, social security cards. It's not uncommon for a person with a disability to not have those documents with them, particularly if they are in an institution or in a group home. So it may take a bit more time to get those kinds of documents gathered. Inability to obtain documents. So the ability to access bank statements and income information might be more difficult for someone with a disability because they don't have access to a computer or they don't have transportation to get to the bank. Inability to search for housing or get to interviews, particularly for people who don't have access to transportation or for whom that is much more difficult. It can take more time to look for housing. Missing deadlines, particularly is a problem for people who may have cognitive impairment or visual impairment, and they don't understand the letter they've received or are not able to read it. That can be a problem. And credit and criminal background issues, which we will cover momentarily. So this slide gives some examples of barriers to housing and some possible accommodations that may be requested for a person. For example, for someone with a vision impairment, if they cannot read the application, they can request it in Braille or in large print or some other alternative format. For a person who doesn't have accessible transportation, they may request that the application be picked up by a friend or family member, or that it be mailed or faxed to them. If they're not able to visit the leasing office due to a physical disability, they can't get there because transportation can't get them there, then the housing provider under an accommodation request can visit the applicant at their home, at the nursing facility, wherever they may be living, to help do that interview and complete that application. If someone has challenges with understanding communications or with organizing their responses to communications, then a secondary contact person can be listed as an accommodation on the application, or during a person's tenancy, a person may request an accommodation to have a secondary contact person notified of all communications so that they can respond in an appropriate manner. As I said, credit can be a barrier for a person with a disability. Sometimes that credit issue is directly related to disability. For example, a person because of disability may have a lot of medical bills or may have a loss of employment. So a possible accommodation could be to waive a credit requirement that the housing provider may have. And as of this year, just July 1st, medical bills under $500 should not be listed on credit reports. So that's a new requirement and something to pay attention to. Sometimes a person with a disability may have credit issues because they haven't been able to pay attention to their bills, or perhaps they don't remember that they had them if there is a brain injury or some other cognitive impairment that's involved. So again, the request could be to waive the credit requirement and or to have assistance from other people to help pay bills. So the housing provider may want the person to demonstrate the current ability to pay bills on time, or enter into a rent payment plan or complete a credit counseling program. Some property management companies may have online credit education programs that they want people to have. So, and in addition, there are many people with disabilities who have no credit at all. Particularly people with intellectual disabilities. And so I always counsel people that having no credit is better than having bad credit, but having no credit is still not good. So someone may need to request an accommodation to overlook the credit requirement because they have not had an opportunity to establish credit. Some possible reasonable accommodations that can be requested in screening that's done by housing providers would be to allow extra time to gather documentation, again, to overlook those credit issues, To overlook a poor rental history related to disability, perhaps a person was having some significant challenges because they weren't stable on medication, weren't paying their bills on time, perhaps had some behavioral difficulties when they were renting, and an accommodation could be requested to overlook that history if some interventions have been happening in the intervening time. So for example, let's say a person was not stable, not taking medication, did not have staff support, but now they are taking medication, they're in therapy, they have staff to assist them with their activities of daily living. So an accommodation could be requested to overlook that poor rental history because now the person has some additional supports. Also considering circumstances behind criminal background that are related to disability, and we will get into that a little bit more detail in another slide. There are accommodations that can be requested to assist with accessing housing. For example, a person with a disability may need to request an accommodation to have a live-in aid, to have an additional bedroom for someone who lives with them and provides them supports for part of their day or all of their day. They may need an accommodation for care attendants. So if a person has staff that come and go different times of the day to assist them in their household activities of daily living, they may need to have additional keys or additional fobs for care attendants to be able to come and go to be able to support them. People also may need assistance animals, and that includes service animals and emotional support animals. We'll get into that in a moment. People may need accommodations in their search for housing. So they may need additional search time, particularly people who need handicap accessible housing may need additional time to find a unit that meets their needs. Or in the same kind of circumstance, they may need an exception to the payment standard for the rent subsidy program that they're using. They may need to go above the payment standard because they can't find a unit that's accessible or that meets their needs within the payment standard. So that's another type of accommodation that can be requested. Again, number of bedrooms, a person may need an additional bedroom for medical equipment if they have numerous or large pieces of medical equipment that need to be stored and that would be hazardous to store in the other parts of the living area in their unit. And then there's also accommodations for different kinds of housing types. As I mentioned, accommodations for an additional bedroom for a living caregiver can be requested. Please note that medical documentation is usually necessary to provide to the housing provider to substantiate the need for the living caregiver. The caregiver must submit some documentation so that they can pass a criminal background check. However, the caregiver's income is not included in household income and their credit is not considered in a background check. The living caregiver does not have rights of tenancy. So while they live there in the unit, they do not have rights of tenancy. And if the person with a disability does not want to have a particular caregiver live with them any longer, they would need to leave. So it's really up to the caregiver. Up to the person with the disability. If the person with the disability, for whatever reason, no longer lives in the unit, for example, if they are readmitted to a nursing facility and are expected to be there for a considerable period of time, then the live-in aid would need to leave right away. The aid is not required to be with the tenant 24 hours a day. There are people who have other supports during the day that they get through their waiver program, or other Medicaid sources. And so the living caregiver may not be necessary to be physically with the person at all times of the day. The caregiver can be a family member, except a spouse. So a spouse is not acceptable as a living caregiver because they, according to HUD, are expected to be providing assistance to their husband or wife. But other family members are acceptable as a living caregiver. But again, those rights of tenancy do not apply to family members because they are living there as a caregiver. Again, medical equipment that's large might require an additional bedroom, and we provided some examples here. Now, assistance animals, HUD has refers to both service animals and emotional support animals as assistance animals. The definition is here for you, and that is that an animal works, provides assistance, or performs a task for a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. So there is a separate and very distinct definition for a service animal. A service animal, HUD has recently noted, is a dog. A service animal can only be a dog, and that dog is individually trained to work or perform at least one task for a person with a disability. Now, that task may be a physical task, sensory, psychiatric, intellectual, or other, but the dog is doing some kind of task for the person. The dog does not have to be certified. The dog does not have to have completed any specific type of training. However, it must be trained to provide a service for a person with a disability. An assistance animal can be any animal that is commonly kept as a household animal. So that might be a dog, might be a cat, it could be a hamster or a gerbil, a ferret, a fish, a turtle, any kind of small domesticated animal that's commonly kept in the home. Reptiles, other than turtles, are not considered common household animals. Monkeys are not considered common household animals. Other more exotic animals are not considered common household animals. A special exception can be requested for a non-common household animal if there is a demonstrated disability-specific therapeutic need for that specific animal. So just note that it is possible, but there's going to need to be additional documentation for some other kind of animal to be approved. The assistance animal, either service or emotional support animal, can go anywhere the tenant goes on the property, including common areas. However, the animal must always be under the tenant's control. Dogs need to be on a leash. I would advise that any other animal be able to be controlled at all times. Housing providers can impose reasonable requirements for vaccinations for animals, but they cannot require licensing because that's really not a health and safety issue. They also can require animals to be leashed and that waste be disposed of properly, because that also is a health and safety issue. When a person has an approved assistance animal, any kind of pet rent, pet deposit is not applicable. Additional renter's insurance cannot be required. Any expenses related to keeping the animal are considered medical deduction from income. So things like food, kitty litter, leashes, obedience classes, vet bills, all of those kinds of things are considered necessary for support of the assistance animal and are a medical deduction from income. So please keep receipts for any of those kinds of expenses, please advise the person you're working with to keep those receipts. And housing providers are also required to accommodate non-residents who have service animals. So if someone has a visitor who has a service dog, then the housing provider must allow that service dog to be on the property. If the property has a no pet rule, that does not apply to assistance animals. Again, that reasonable accommodation needs to be requested and documentation needs to be provided. So a housing provider can ask if the person has a disability. If the animal's a dog, then if it is a dog, is it providing work? Is it doing some kind of work for the person? Then it's considered a service animal. If it's not a dog, or if it does not do some kind of task for the person with a disability, it will be considered a support animal. The animal must, be under the person's control at all time. So if that animal poses a threat to anyone on the property, if it poses a threat to other animals that might be pets in a pet, a property that allows pets, then the housing provider could request that that specific animal be removed. However, the accommodation for having an animal, a service or emotional support animal would still remain. And the person with a disability could have a different animal in their apartment. This slide just sort of gives you an easy reference on which animals are service animals and which animals are support animals. Criminal background issues, I'll go over that just briefly. It is possible to request an accommodation to overlook criminal background. If that criminal background occurred when a person, again, was not stable on medication, did not have the kinds of staff support that they may need, or some other kind of training program that they may need for anger management, et cetera. And now they have acquired those supports, are stable on medication, those kinds of things, then an accommodation to overlook that criminal background could be requested. Also, passage of time, if the criminal background happened more than 10 years ago and there have been no subsequent problems, a person could request that that background be overlooked. Sometimes a person may have a background related to substance abuse, but if a person has completed a substance abuse treatment program and is not currently abusing substances, then that kind of criminal background should also be overlooked by the housing provider. Again, there's got to be a nexus or a connection between the disability and the criminal activity. Accommodations must be provided if it would reduce the threat or provide equal opportunity. And there are two exceptions to this criminal background. There are two criminal background conditions which cannot be overlooked. That includes persons who have a lifetime sex offense registry requirement and persons who have been convicted of the production or sale of methamphetamine on federally assisted property. Those are the two nevers, two conditions where a person cannot be housed, even with a reasonable accommodation request. Screening can be done as long as the property screens everyone. The property cannot just screen people with disabilities for criminal background. They subsidized housing providers can, and there are federal guidance for this, which we will give you handouts so that you can read about it. But housing providers can only deny an applicant based on convictions, not based on arrest records. So there has to have been a conviction, not just an arrest. Private, non-subsidized housing providers have to evaluate whether the criminal background policy has a disparate impact on any particular protected class. And there's been a lot of equity information that's available out there and in the news about this kind of issue. So the housing provider needs to make sure that whatever their criminal background policy is not impacting one particular protected class over others who are not in that protected class. And denials, as I said, based on arrest records or blanket bans on anybody with a criminal background do not meet this test. A note about inability to care for oneself or the unit. Leslie mentioned this earlier, but there have been some instances where housing providers are requesting that people have independent living skills, or that they sign an agreement that they can be removed from their unit if there's some kind of concern about a person's ability to care for themselves. These are illegal. A lease can only be ended if there's a breach of the lease terms. So if the person has not breached lease terms, they cannot be evicted because the housing provider has a concern. Of course, reasonable accommodations could be requested to mitigate any kind of breach of the lease. And emergency contact forms that authorize someone to remove somebody from the unit are not legal. So if you're encountering those things, please let someone know that can assist with overcoming that issue. In Maryland, it is possible for someone to terminate their lease early if they have a medical need to leave the unit. Let's say someone's got a change in their health condition and they need to go to a nursing facility and cannot fulfill the entire lease term. They can request to move early. The housing provider can require the person to pay 2 months rent to sort of mitigate their damages. But other than that, they must release the person from their lease obligations. Reasonable, now sometimes threatening behavior can be an issue for a person. Reasonable accommodations can be requested for people who are having difficulty, perhaps getting along with the property manager or something like that, to allow them more time to get additional treatment, to get additional supports in place, etc. If the person poses a direct threat to the community, however, if a direct threat of harm or gesture or act has happened, then the person can be removed from the property because of this direct threat. The individual and not the type of disability must pose a threat. So a property provider cannot say, well, all people with behavioral health disabilities are dangerous. Therefore, if you have a behavioral health disability, you can't live here. They must consider the individual circumstances. There are reasonable accommodations that can be requested to prevent eviction, and those are listed here that you could take a look at if this is something that the person you're working with is facing. Now, briefly, I'll cover how to make a reasonable accommodation request. So a reasonable accommodation request can be made by the person with a disability, by a healthcare provider, or by a family or friend. It can be made by anyone. It does not have to be made by the person with a disability. A reasonable accommodation or modification request can be made to anyone employed by the housing provider. That includes the property manager, the owner, maintenance staff, the receptionist, anyone who's working for the housing provider. If a person is asking for an accommodation or modification, then that's considered a legal request. An example would be, maintenance may be in someone's home, replacing the HVAC filter, and a person may say, I really need a grab bar because I've slipped several times when I'm getting out of the bathtub. And that would be considered a reasonable modification request. Again, a request can be made at any time during the application process, tenancy, or eviction process. And the request does not have to be in writing. It can be verbal. It is best to have the request made in writing. We always recommend that that be done because you have the documentation of when the request was made, and it is more specific. So when you put the request in writing, you can be very specific about what the need is. However, it can't be required to be in writing, and the housing provider cannot require someone to fill out a particular request form. However, for medical documentation, forms can be requested, and the medical documentation needs to be provided in a particular way. So the medical documentation can come from any healthcare provider. And I think I've got a slide coming up on that. Here we go. The medical documentation could be provided by any healthcare professional who has sufficient knowledge of the person's disability-related needs to substantiate the need for the accommodation or the modification. And again, remember, there has to be a connection or a nexus between the accommodation and the modification and the request from the person with the disability. So healthcare professional could be a nurse, a case manager. It can be a physician, but it doesn't need to be. It could be a therapist, anybody who's a healthcare professional. A specific form for medical documentation cannot be required. If it's reasonable for the person to go ahead and use that documentation form, then that's okay to do it, but it can't be required. In fact, when a person makes their accommodation request, they may submit medical documentation along with the request. So, and that's okay to do. The person also cannot be required to disclose any specifics about their disability or to provide a copy of medical history. So when making a request, it is not necessary to disclose a diagnosis, just to describe, it's only necessary to describe why the accommodation or modification is needed and how it relates to the person's disability. So for example, a person may say, I'm requesting a grab bar because my ability to ambulate means that I slip more often, that kind of thing. Or I'm requesting that the credit requirements be overlooked because I have had numerous medical bills related to my disability, but no need to provide records or to provide a diagnosis. So what happens next? If the request is approved, a response should be provided about when the accommodation or modification will be implemented. So especially if it's a modification, it may take a little bit of time for the housing provider to review plans and get a contractor if they're paying for it, or for you to get a contractor, et cetera. But HUD has said that it's best practice for the response to be within 10 days of submitting the documentation. It has to be done in a timely manner. If the request is denied, a reason has to be given. And I have seen requests denied where it just said no. So that's not sufficient. A reason must be given. And the housing provider needs to engage in that interaction with the person to see, well, your request couldn't be accommodated, but perhaps this other way of accomplishing what you need could be done. And maybe we could do it that way. If the denial is due to financial burden, the housing provider must explore whether the work can be done in phases, whether the work could be done perhaps in a few months when the housing provider has more resources available. So again, that dialogue needs to happen. So we've only got no minutes now for questions. I'm willing to stay on for a little bit if people want to ask questions. Chelsea, are you able to do that for maybe 5 minutes? Not sure if Chelsea's still with us.
She said yes in the chat.
Oh, okay, okay. So Chelsea, have you monitored the oh, 1 sec. So we'll give her 1 sec because she's got to get her headphones. And let us know what kind of questions we may have here in the chat or in the Q&A. I see one question here. Because we are attempting to go completely paperless, can we mandate that our elderly and disabled population have email and scanner capabilities? Some of our elderly and disabled population have indicated that they either do not want an email or even know how to use a computer. Very true. Can that be considered as a reasonable accommodation and they are allowed to continue in the paper world? My answer, Charmaine, would be yes. If a person does not have the ability to use a computer, does not have access to computer, a person may have either a physical disability that prevents them from using a computer, or perhaps an intellectual disability that prevents them from using a computer, then a paper process would need to be able to be continued, or some other process that accomplishes what you need, that is something the person can do. And that's where that interactive process is really helpful, because talking with the person or their healthcare provider or their family, friends can help figure out what's going to be the best way to accomplish what's needed. We have another question here. What is fair share, mainstream, and NED 1 and 2 housing? Also, are USDA housing only in rural area of the country? Okay. Fair share is a housing choice or Section 8 voucher. And it is kind of the basic kind of voucher that anybody would, who income qualifies and otherwise qualifies, would be able to get. So it's not specified to any particular population. A mainstream voucher is a voucher that's specifically for a person with a disability. And more recently, some mainstream vouchers are prioritized for particular populations, including people who are institutionalized or at risk of institutionalization, and people who are homeless or at risk of homelessness. NED stands for non-elderly disabled, and NED Category 1 vouchers, and there are a few in the state, are specifically for, are for people who are people with a disability who are under the age of 62. Non-elderly meaning under the age of 62, so between age 18 and 62. NED Category 2 vouchers are specifically for people transitioning from nursing facilities. That's the smaller category of vouchers. NED Category 1 vouchers are relatively common throughout the state. NED Category 2 vouchers are less numerous and are specifically for people transitioning from nursing facilities or other institutions to community. USDA housing is typically in rural areas of the country. I'm not exactly sure what the definition of rural is, so I believe there can be USDA housing in Frederick County and parts of Frederick County, certainly Washington, Allegheny, and
Yeah,
Garrett.
I think that there are. Yeah.
Yeah. Are the 5% UFAS and 2% hearing vision for new construction sub rehab based on unit count or square footage? I guess SF means square footage. The percentages are based on units, and they are applied across all unit sizes. So that, for example, that 5% UFAS would have to be a combination of 1, 2, maybe 3-bedroom units if the property has 3-bedroom units. So it can't all be all 1 bedrooms or all 2 bedrooms, et cetera. It's got to be spread out across the bedroom sizes, as well as the 2% hearing and vision. Let's see, what other questions do we have? Or maybe something from the chat. Chelsea, have you monitored?
Hey, yeah, there was a couple questions that came up. So, and some of these I can answer. Okay. Shanika asked, is there a limit to the number of service or assistance animals that one resident can have?
I do not believe there is a limit. At least there didn't used to be. Now HUD's more recent.
Yeah.
Limiting to service animals to dogs and common household pets. You know, as long as the unit is maintained in the way that's required by the lease, and as long as the animals are under the person's control, and the waste is disposed of so that it is not a health hazard or bothering other folks, then the number of animals I do not believe is applicable. But I have not heard anything different than that.
All right, we have another question here from Etta. If the participant is ASD and requires assistance and communication or interaction with the landlord, requesting the landlord to wait for communication until the assistance is present, would they want a reason why? Are they allowed to ask? And is the case manager allowed to inform?
Right, I hear the question. Basically, the answer is yes. If a person who has autism spectrum disorder or any other disability has a need for assistance with communication, and there may be a delay in getting that assistance. So for example, it might take a while for the case manager or housing specialist to meet with the person and then meet with the property manager. A reasonable accommodation request can be made to allow that process to happen. The specific diagnosis does not need to be disclosed. I would just say that the person's communication needs require that the case manager or the housing specialist or family or whoever be with them. And we're asking for an extension in the time frame to respond to enable that assistance to be provided. But no diagnosis needs to be given.
All right, so Etta asked also, and I believe this was in reference to the federal requirements that you all went over. She said, why only meth? What about other drugs, drug manufacturing, sale, etc.?
I'm not sure the why. I've speculated that it's a fire hazard. But I'm not exactly sure why it's specific to the sale or production of methamphetamine. Leslie, I don't know if you know any other whys for that. But those are, the two specific nevers in the housing assistance, federal housing assistance program.
I don't know specifically why, as far as the meth, except there was a time period when that was really rampant. And so maybe it's kind of stuck there. They haven't revised it yet, or maybe it's just because that is something that people could easily make.
Right.
Unlike some other drugs, but yeah, I don't know specifically either.
Thank you.
All right, there is another question in the chat. Who can we contact if we have a consumer whose lease is being denied renewal because of her support dogs, which she had to let go of? Who can we speak with about this matter? I recommended the Fair Housing Action Center of Maryland, but also filing a complaint with HUD or the Maryland Commission on Civil Rights. I don't know if you all have other recommendations on that one.
I mean, someone can call Disability Rights Maryland intake. It's always better to call before the event has taken place rather than after the fact. But they could call and see if we're able to help them.
I saw that someone was raising their hand. and wanted to ask a question. Chelsea, are you able to facilitate that?
Yeah, I have asked Ashanti to unmute.
Okay.
Ashanti, you should be able to talk now. Ashanti, you were unmuted. Oh, she says she doesn't think her mic is working. Did you want
Oh,
to ask the question in the chat then?
we'll give you some time to type it out.
Yeah,
Sometimes that's why people want to ask rather
right.
than do all that typing. I get it.
Just to, while she's typing that, I've had a few people ask me about the PowerPoints from the prior presentations. I send those out automatically, so I ask for you all to be patient with me as I have multiple other responsibilities. So I have not forgotten about sending those out. I will make sure that everyone who attended gets a copy of the PowerPoints and a link to the recording online. Oh, Ashanti says all of my questions were answered. Thank you. Okay, great.
I'll also say that there are some handouts that we typically give related to this presentation. Chelsea, I will send them to you for you to go ahead and send along with the PowerPoint. So I'll get all of
Sounds
that.
good.
But
Okay.
those handouts include things like which law applies. That's a really useful one. And it also provides copies of the HUD guidance electronically, so we don't have to print it all out.
And I quickly mention, excuse me, that, and people may already know this, but just in case they don't, that if a landlord is threatening to evict someone, they're required to go through the court process. So sometimes people just move out. So nobody should just move just because they got a letter saying, we want you to move. They should contact DRM or legal aid or, someone and, maybe they can get some assistance. But even if they don't have a lawyer, there's notice requirements, of 30 to 60 days, depending on what the claim is. And then the landlord would have to file in court. So it's actually a process. So, even if someone is going to end up moving, they're going to have probably at least an extra couple months before they have to move out. So I just wanted to make sure people were aware of that.
Thank you. All right, are there any other questions? I'll just give another minute, and otherwise it looks like we do have a question from Etta. Do you find that non-visible disabilities specifically I'm not sure what you mean by NF, because I usually think a nursing facility and that doesn't seem to fit there. But anyway, non-visible disabilities are discriminated against more than others. How can the case manager let the landlord know without breaking HIPAA? I see that Chelsea has answered this, but I do think that non-visible disabilities may be people with non-visible disabilities may experience discrimination more than others. And, but again, that medical documentation is why it is so important. And if someone feels like they're being discriminated against by a landlord, then certainly they should contact Disability Rights Maryland or Legal Aid or somewhere. It would not be, I do not believe it's a HIPAA violation to provide the basic information that this is a person with a disability, especially if the person with a disability gives permission to say that they are a person with a disability. And again, without providing specific information or medical records, then it's not a HIPAA violation, and it's actually required by the law when accommodations are being requested, that some kind of medical documentation be provided for things that are not readily apparent to the housing provider. So. Well, if there are no other questions, then I will say thank you.
All right. Thanks, everyone.
So thank you all very much.
Have a good one.
Thank
Take
you.
care. Bye.
Bye-bye.
Bye. Bye.
Bye-bye. I'm going to try to stop sharing now. Stop share.